Here's another way of illustrating the court's argument that there was good consideration to support a contract between Satterthwaite and New Zealand Shipping. It can be useful sometimes to write down what are the benefits and what are the detriments to each party. In a case of good consideration, we expect to find that both parties have both benefits and detriments, and it is no different here. Satterthwaite gets the benefit of its cargo being unloaded. Satterthwaite gets the added benefit that it can now sue New Zealand Shipping in contract. If there's only a contract between Satterthwaite and Federal, well then obviously Satterthwaite can only sue Federal in contract, but now they can sue someone else, so that's a benefit. New Zealand Shipping's benefit is very simple. It's the benefit of the exclusion clause. The exclusion clause that was agreed between Satterthwaite and Federal, which now extends to New Zealand Shipping as well. Both parties also have detriments. Satterthwaite has a detriment because it now only has 1 year to sue New Zealand Shipping because of the exclusion clause. New Zealand Shipping has detriments which match the benefits of Satterthwaite, namely that it actually has to go and unload the cargo and that it can now be sued in contract. It's also useful to spend a few moments looking at the dissenting opinions. In fact, 2 of the 5 Privy Council justices disagreed that there was a contract between Satterthwaite and New Zealand Shipping. Those 2 found that the contract between Satterthwaite and Federal Steam Navigation was just between those 2 parties, and anything it stated was subject to privity. What that means is where the original contract between Satterthwaite and Federal Steam Navigation says that certain privileges such as the exclusion clauses shall apply to third parties, to contractors, agents, and so on, those are points which have been agreed between Satterthwaite and Federal Steam. Only those 2 parties can sue upon that. Now, you have a third party, New Zealand Shipping, coming in trying to get the benefit of that. Under the normal rules of privity, that's not possible, and that's exactly what the 2 dissenting justices found. They also found that the exclusion clause itself was not capable of representing a unilateral offer in the way that the majority had explained that it was a unilateral offer and that a contract came about between Satterthwaite and New Zealand Shipping at a later point in time. Now, the minority said that was not possible because Carlyle and Carbolic Smoke Bowl, which is the case that provides us the guidance on unilateral offers, also says that unilateral offers have to provide what the mode of acceptance is. In other words, anyone who reads a unilateral offer should be able to tell what they need to do to accept that offer. And in the opinion of the 2 justices and the minority, the exclusion clause did not provide any guidance on mode of acceptance. To understand the minority opinion, perhaps most significantly, we have to point out that the exclusion clause in the original agreement between Satterthwaite and Federal Steam Navigation mentioned the word contract in the singular. Specifically, it said that the benefits under this contract, such as the exclusion clauses, would apply to third parties such as contractors. Now, by using the word contract in the singular, it seems pretty clear that the 2 original parties, Satterthwaite and Federal Steam, agreed that there was only going to be 1 contract and that that 1 contract would extend to third parties. Now, we know, because of privity, that that's not possible. So perhaps they just drafted it poorly, and this is exactly what the minority felt was the case. The minority felt that if there was going to be an additional contract, a unilateral one in a Carlyle and Carbolic Smoke Bowl way, then the original contract should have stated that. So for instance, the original contract could have said that there's certain exclusion clauses that apply as between Satterthwaite and Federal Steam, and further, it could have stated that Satterthwaite is also deemed to have made a unilateral offer to any contractors involved in performance of the carriage for transport of this shipment to New Zealand, and if anyone else comes along, they may accept by carrying out whatever services they were supposed to carry out. So this could have been spelled out in the contract, but it wasn't. The exclusion clause only refers to the contract, which it purports to extend to third parties. And that's why it's probably likely that the minority was correct, that a plain reading of the exclusion clause, as between Satterthwaite and Federal Steam, the original contract, a plain reading means that it is subject to privity and it cannot extend to third parties. That said, that was still the minority. Whether we agree with it or not, the majority was 3-2 to the effect that it is possible for parties A and B to have an agreement, have a contract, and in that contract indemnify third parties such as third party C, in this case the stevedores, the people who unloaded the ship in New Zealand shipping. The consideration requirement, in order for all that to happen, is attained if party C, so in our case New Zealand Shipping, performs some sort of service that is of benefit to party A. And in this case, of course, that was the unloading of the ship. Here, very importantly, it does not matter that party C was already under an existing contractual obligation to perform the service. And this is one of the main things we take away from this case, specifically that if two parties have promised something to each other, then the performance of those promises can be used to essentially pay for a new contract. So let's say B and C, in our case, B would be Federal and C would be New Zealand Shipping. B and C have agreed that C would unload the ship and B would pay C for that. Now, the mere fact that C does what they already promised vis-a-vis B, namely unloading the ship, can be used to support a new contract between A and C. So this is an exceptional rule in relation to consideration, because of course the normal rule is that you cannot use performance of an existing contractual obligation to essentially pay for a new contract. If you want a new contract, you need to provide new consideration. But as we see from this case and previous cases, that does not apply where third parties are involved. It's also important to note that the minority didn't say there could never ever be an arrangement whereby A and B agree to indemnify C. It's just that the contract as it stood in the present case, the exclusion clause as it was drafted, didn't achieve that. It was just not drafted correctly to achieve that purpose. It didn't allow for such an interpretation. So let's try and summarize the two main legal principles that we can extract from this case. Number one, a third party, whom we called C, who is under an obligation to perform a particular service, namely to unload the ship, and that obligation is to B. That party C can perform that service, which it already owes to B, to pay for a new contract with A. So the same act, the same performance can essentially pay for two separate contracts. We know that because of this case. We also know it from a much older case, Scottson and Pegg. Second legal principle that we extract is a unilateral offer in the sense of Carlyle need not spell out the mode of acceptance. It suffices if the offeree performs a service or provides something that is of benefit to the offeror. Because remember, the exclusion clause itself never said how third parties need to act, what exactly they need to do in order to accept the unilateral offer. It was just the fact that they did do certain things, in this case unload the ship, which then provided the acceptance of the unilateral offer in the view of the majority of the Privy Council. I hope this video has helped you understand this rather complex case a bit better. Thanks very much for your interest.